Namaskar and welcome to Sansad Television. I am Vishal Dahiya and you're watching our show Perspective, where we bring you detailed analysis of national and international issues. Today we're going to talk about various aspects of the justice delivery system. Now, President Droupadi Murmu has urged the executive, judiciary and the legislature to evolve an effective dispute resolution mechanism to mitigate people's plight. In her valedictory address at the Constitution Day celebrations organized by the Supreme Court last week, the President said that it would go a long way in making citizens effective stakeholders in the dispensation of justice. She also recalled her days as a political activist in Odisha to highlight that the excessive cost of litigation was a major impediment in the delivery of justice. While there is a huge backlog of pending cases in the courts from the district to the apex court, various studies have also revealed that legal system is too expensive for most litigants. Both judiciary and the government has in the past taken several initiatives to deal with these issues. But how successful have these steps been, and what more needs to be done to further improve the justice delivery system in our country? To try and understand these aspects in a much better way and what exactly can be done and what ails the justice delivery system, we have with us a distinguished panel of experts. Let me first introduce them to you, beginning with Satya Prakash, who is joining us here with me, legal editor with the Tribune. We also have with us Mr. Dushyant Parasha. He is an advocate with the Supreme Court of India. And Mr. Suresh Chandra is also joining us, former law secretary with the Government of India. Welcome, all of you gentlemen, to Sansad Television. I'll begin with you first, Satya, and then we'll come to the major issue again. But since, you know, it all, this has been discussed a lot, but since the President herself was making a reference to it in that event, if you could take us through as to what was the, basis, or what was the summary rather of what the President was trying to convey to everybody present there, from the executive to the judiciary to the legislature as well.
Well, the President, she went out of her written speech and then she narrated what she wanted to. And she, all of a sudden, she, from English, she switched over to Hindi, and then she narrated her own personal experiences. When, as an MLA, she was part of some standing committee in the state legislature. She visited jails, and then whatever she tried to do as an MLA and being part of the standing committee, and thereafter as a governor and now as president. It was a very, very emotional sort of appeal. The CJI sitting, the law minister sitting, and all the judges of the Supreme Court, and the bar leaders, and there were others also. What she was trying to convey, that something needs to be done to reform the entire system to make it much more accessible to the common man, because she talked about prisons, where she herself has visited several prisons. She talked about prisons. She talked about exorbitant fees in terms of the cost of litigation she was talking about. And she said it has to be, something has to be done. And she said, I leave it to you, because you are all learned people and much more experienced in this field than me. So I leave it to you. And without saying much, at that point, she ended her speech. Okay. So she has raised the issue, raised certain questions, and then left it to the judges and the government to do something. And I suppose the judges, including the CJI, they were all listening to her very carefully and very attentively. Okay. So I expect them to do something in the coming future.
Indeed, coming in from the highest constitutional authority in the country, this does merit a lot of looking into. But let's, I'll bring in Mr. Suresh Chandra here as well. Mr. Chandra, the simplest question would be to try and understand what ails the justice delivery system in India. As in, there are several issues which are being talked about. As Satya was pointing out, the President herself referred to issues with regard to the way prisons are run, or, prison reforms, one aspect we are looking at, cost of litigation, of course, accessibility to justice as well. But these all are the terms which we have debated and discussed over the years quite a number of times.
Yes, thank you. It's a very hot topic, and it is the topic which has not been raised for the first time. Every time you see justice delivery system is being highlighted, being inefficient, ineffective, people suffering. One thing I would like to highlight on this platform that the administration of justice is no one else responsibility than the king's. It is the only function which has to be discharged by the king. It has to be seen. But if you see in number of days, a lot of people other than the judiciary is also involved in justice delivery system. And in this process, what you have come, earlier there used to be one or the second appeal and SLP in the Supreme Court. But nowadays there will be one tribunal, then again there will be another appellate tribunal, then again there will be the High Court, then the writ jurisdiction, and then again appeal, and then the Supreme Court. The timeline is too much elongated. I don't know that everybody has to think over it as to what has happened to our system, that when there is a provision of 2 appeals, nowadays if you see there are number of appeals. Number 2, earlier there used to be only 3 wings, the legislature, executive and the judiciary. Nowadays lot of tribunals, lot of commissions, lot of administrative tribunals. I fail to understand whether these are falling within the definition of executive or in the judiciary or in between something. So now you have raised the issue, what is ailing? I will say awareness amongst the people, citizens have increased, so numbers have increased. Earlier there used to be filing in 1999, there were filings around 11 lakh cases in the high courts, and some odd cases around 1 crore 27 lakhs in the subordinate courts. In 2006, the disposal was much more, that is 14 lakhs. Okay, but the filing was again 15 lakhs and something. But in the subordinate courts, the filing was in 1996 1 crore 56 lakhs, and against that disposal was 1 lakh 58. So it has increased, and reason for this are some of the reasons, if time permits. One is that we constituted fast track courts during that period. There were some states like Gujarat took the first step in organizing evening courts. Okay. And that has also brought down this. Then the legal aid system, including the under that Lok Adalas, lot of cases were being disposed of in that. But still something is lacking. Like lot of cases on 138 is still clogging the this. A number of trials in lakhs, that is also clogging the system. So there are again issues which are raised, including the number of judges, including the conditions. If I remember when the Prime Minister was addressing in Vigyan Bhavan, the then Chief Justice of India was crying that my judges are sitting before the trees and dispensing justice. They do not have adequate facilities. So reasons are many, but I will say, in one word, if I say that there is a competency crunch at the level of executives who are giving certain decisions which are ambiguous or not taking objective decisions. Second, the disposal by the judges who are sitting. Sometimes a competent judge can dispose of 100 cases, but there are instances when the judge, one single judge, has not disposed of a single final judgment in the whole career. That is also true. So
this whole gamut of issues, makes up for that that obstacles in the justice delivery system which we are talking about. Let me bring in Advocate Parashar here as well. You must be dealing with clients on a daily basis. Now, if you have to understand much better, what is it that a litigant looks forward to? Of course, the speedy delivery of justice, but it doesn't happen so easily. So how do a lawyer and a litigant deal with these issues? Because from a litigant's point of view, it's a maze which he will have to navigate via his lawyer.
The answer to this would be a lawyer and litigant. A lawyer, it depends on, you see, to answer it straight, a lawyer once being assigned the case by the litigant, he has to work and he has to be ready. I have to perform duty on my part and I have to go ready before the court and I have to argue my case. Now it depends. So I am not the party. There are bipartite. You see, it's an adversarial system.
Indeed.
So the court, both side lawyer. So I am ready. The opposite side counsel is also ready, and the judge listens to our arguments and give the judgment. So it varies, or it depends on many factors. And I will say that my system had improved a lot. Judicial system of disposal of cases are very fast than prior position. And today the judges are very upright. They are keen in disposing of the cases. Given the chance, the lawyer is ready. Exceptions cannot be made benchmark for laying down the principles. So today the population is increasing. You see, if we talk about pendency of cases or number of cases, so we have to see both sides of the coin.
Okay.
So population is increasing, naturally the litigation will go on. Number of judges are there is a limit to the number of judges in higher courts, in lower courts. So all in all, the judges are performing to best of their ability. It's a lawyer's duty to perform to the best. I, being a lawyer, I can say about the fraternity, barring exception, that every lawyer is ready and comes prepared with the case and argues his case.
Okay.
Nobody is really interested in delaying the justice.
Then how is it getting delayed?
Now I answer it. See, the justice is not being delayed. There is a difference. If now you have to go you have to see the country as in total. India is very diverse. India consists of villages, city, ultra-modern city, many things. It's a stretch. So if you talk about somebody who is in village in Balasore, in Odisha, or in Jharkhand, or in Bihar, or in Paschim Mednipur, in West Bengal, yes, of course, their awareness is what required. And let me tell you, put it on record, that Nalsar, under the leadership of the then Chief Justice of India, retired Justice U. Lalit, had disposed of 10 lakhs of cases. And the Nalsar went to the far-flung area of the country, in Shillong, in those areas which is not, they have not heard of what is this justice system and how to do arbitration and how to finish it off, small cases. So the justice system, in disposing of the cases, I will be wrong in saying that the system is delayed or system is delaying or justice is being given very slow. It depends on many factors.
Okay.
But if you talk about Supreme Court, if you talk about high courts,
okay,
yes, of course, in lower court, when evidence has been taken, because a trial, when it commences, it depends on various steps already enumerated in CRPC. So if witnesses are not turning up, but naturally it will be prolonged.
Okay.
But so to say that we are not getting justice, or the litigants are not getting justice, or the countryman is being deprived of the justice, I disagree with this. I say today the position the last 10 years has improved much.
Okay.
And Nalsar, if you talk about Nalsar, their objective and the performance which they have done, which is in public domain,
okay,
they have done brilliantly, and District Legal Service Authority.
Okay, but you know, there is still scope for improvement, and that is always there.
I'll take one more minute. Improvement is the essence in any democratic system, be it judiciary, wherever it is.
Okay.
And that is happening day to day. If you see the initiative of Supreme Court for disposing of, now the Chief Justice says, the previous Chief Justice, the present Chief Justice, and talk about all the Chief Justices, that those matters for which we have granted a stay, which involve constitutional position, let us first finish it off, because once we will decide it, then the courts below, who are waiting for the command and legality to come up in public domain, what is the law, then those cases which are shown as pendency will come to zero. So therefore, it is India being very vibrant. If you see the population, so therefore, every day the country or the judiciary or for all branches, democratic setup, they are striving to achieve the ultimate, the poorest of poor should get that. And that too, Nalsar, and if you talk about all the judiciary as a whole.
We'll come to that aspect as well. The intent is, of course, not under question here. But Satya, moving on to the other part, and I'll come back to you on that. Satya, let's look at one aspect which the President herself was also pointing out, and that is the cost of litigation. And several studies have also revealed, over the years, that the cost of litigation is excessive for most of the litigants. How has that been addressed over the years, or is this really an issue?
Well, of course, this is an issue. But before that, I'll just respond to what Mr. Parasar has said. This is a question of abject failure on the part of the judiciary in foreseeing the problem which is going to hit them. India is going to witness litigation explosion because of the rise in literacy and education in India, and because of rise in income levels. People are going to assert their rights. So the number of cases filed, it's going to rise phenomenally. And the judiciary is completely unprepared for that. And what we have witnessed is from 2 crores to 3 crores, and now the cases are, pendency has risen up to almost 5 crore. And what I see is that there is a complete lack of manpower, be it at the district judiciary level, be it at the High Court level, and Supreme Court also. Currently, we have around 7 vacancies. So there has to be a mechanism through which you fill up the vacancies in time. And then you have to take into account when certain posts are going to fall vacant. And 6 months in advance you plan it. Forget about the increasing the number of judges. The existing vacancies have not been filled. And you cannot blame the executive, you cannot blame the legislature. It is even at the district level, the entire district judiciary, it functions under the High Court, and High Court is supposed to take care of this. So there is a huge number of vacancies in the trial courts, in the High Courts, and today also there was some case in the Supreme Court regarding vacancies. The Supreme Court is talking about certain recommendations which are pending with the government. But they are not talking about the recommendations which they were supposed to send, but they have not sent. And because almost 30 to 35% posts in High Courts are vacant, and there are hardly any recommendations. There are few recommendations which are pending. That's a different thing. So the judiciary is going to hit by, or India is going to hit by a litigation explosion for which nobody is working that hard. Because you have to take into account the number of cases which are going to be filed. And this is going to rise. They have their own study has projected that the number of cases being filed, it's going to rise phenomenally. And they are supposed to do the work. The second part you asked.
Coming back to the cost part of it, making it more affordable, as the President was referring to.
Article 39, capital A of the Constitution talks about it. And then the NALSA Act was passed in 1987. It was made operational in 1995, and since then, those who cannot afford a lawyer, there is a provision at the district level, at the state level, and even at the Supreme Court level, where free lawyers are provided from by the NALSA or a state legal services authority, or at the district level. So there is a provision under the law through which competent advocates are provided to litigants who cannot afford a lawyer. And there are categories and there are certain criteria which one needs to fulfill. Like for that matter, a child or a woman is automatically entitled, or a scheduled caste or scheduled tribe community member is entitled, and there are certain income criteria also, state-wise they have notified. So it is not that lawyers are not available. The only question is the quality of lawyers. I am sure at the Supreme Court level they get good quality lawyers for assistance. I'm not sure about what kind of lawyers or legal assistants, people who approach the district legal services authority, whether they get competent lawyers or not, I'm not sure, because I have not witnessed at that level.
Mr. Chandra, when we're talking about the cost aspect, and that is really important, because, from the litigant's point of view, it becomes a real burden in cases which are dragged on, or where they're not even aware, as Advocate Parashar was also referring to, that the awareness part is really important. So where do we stand? Of course, Nalsar and various other steps which have been taken by both the judiciary and the government as well, they seem to be giving results. But are those results in tune with the kind of challenges which keep on building up as the time passes by?
Here I agree with Satya Prakash, and we have number of measures, number of institutions to take care. But again, as I was referring to earlier, a reason of dispute arises when there is a wrong administrative decision, or at least there is unambiguous kind of thing, or discretion which is exercised is not above board.
Okay.
This is one of the reasons. That's why injustice. When it goes to injustice, then where it should go? Earlier, there was only used to go to the courts. Now, these are not courts. And what Satya Prakash is telling about the legal service and all that, these are available only before the courts. There are number of tribunals, there are number of commissions, there are number of other organizations which are quasi-judicial in nature that has not been taken into.
Okay.
But it has not only multiplied the dispute, it has added certain layers also.
Okay.
Because ultimately it reaches to the high courts and to the Supreme Court. Thereafter it goes. But by this time, the delay part is too much.
Is a burden on litigants.
It's a burden. So now, if you say in few cases we give free legal aid, wherein sometimes the quality of the advocates which are on the panel of the NALSA and all is also a little bit in controversy. But again, taking it into consideration, if you see, there are other areas wherein the cost part is very high.
Okay.
And that is true. And nowadays there are people are saying about the alternative disputes, out of court settlement, this court settlement, arbitration, and if you take the fees in those, then you will wonder that one judge, one arbitrator charges in lakhs of rupees for one sitting, whether he hears or not, that fee has to be paid.
Okay.
Then the counsel who is appearing, he will also charge.
Okay.
So the cost is huge.
Indeed, those mechanisms do have their own aspects here. We're running short of time, but Advocate Parashar, on the cost part, and just not about the cost, it is very closely linked also to that aspect of making the justice delivery system accessible to the population at large, to the citizen, the common man of the country, who is now a litigant. When we're talking about justice delivery system, that common man is a litigant, either in the form of a defending party or the prosecuting party. So therein comes these two aspects. How are these being dealt with? As you're pointing out earlier, Nalsar has done a good job, dealt with around 10 lakh cases in far-flung off areas, and making people aware is a very important aspect there.
That's right. So therefore, now there are two limbs of it. Cost to be one who can afford the cost issue is no more res integra, that need not to be discussed. Now, as far as poor is concerned, cost become relevant with the poor person who cannot afford a lawyer. So if you see District Legal Services Authority, State Legal Services Authority, and then Supreme Court. Supreme Court has Supreme Court Legal Services Committee, in which I am one of the panel counsel. I render legal assistance. So therefore, we have the hierarchy of Legal Services Authority, which is being constituted under NALSA. We have panel of counsels, and all the counsels are competent, barring exception. Now the question is how to deal with the cost part. So therefore, they have not to pay a single penny. The litigant had not to pay a single penny when they are being provided lawyer from Legal Services Authority, and they do their job. They defend or prosecute. Now, in order to make it, now the question, the pure hardcore question today here is how to make the people aware about it. The moment awareness goes across the country in nook and corner, there and everywhere there is Legal Services Authority. So to say today what President had said, that affordable justice, I totally agree, and I say today that India stands today at a position wherein India affords to its poorest of poor in sync with Article 39A, Article 21 of Constitution of India, and within the preamble and vision of Nalsar. And if you talk about justice in preamble says, justice should be in all sort of life. So therefore, today I say that the affordable justice, as the President Murmu said, that those people who are in jail for 20 years, 25 years, they are not able to get assistance of a lawyer. I say today that with all due respect to the statement made, the Legal Services Authority are imparting, they are performing tremendously well. And now I visited Tihar as a Council of Supreme Court Legal Services Committee, interacted with prisoners across. I went to jail number 5, which is hardcore criminal jail. I went to all the jails, interacted for 5 hours, and then interacted and I asked what legal services you require from me and counseled them. So therefore, we have really moved on.
Okay.
And as far as cost and affordability of litigation is concerned, the rich, they easily afford. For the poor, we have a mechanism in place. And I am part of that mechanism.
Is that, one small addendum here, is that mechanism as competent and as strong at the lowest level possible as Satya was also
I'll answer that. Now, if you see, that is competent and strong. Answer is yes. And to explain it in 1 second, because if you talk about at the district court, my family members are lawyers who are part of District Legal Services Authority. Let me put an example, which I see on every day. Now, once a case is being filed, suit is being filed in trial court, it is being assigned to one of the panel counsel.
Okay.
He conducts it. Now, if you talk about the poorest of poor, he has to be made aware. I have to tell them, please come. We have to create awareness program to the poorest of poor and tell them, look here, you have a services authority which will impart justice to you. You can get justice, you can get lawyer free of cost. That is what we have to work on. And that was the vision of former Chief Justice of India, Justice U. Lalit, which is being taken care of by now our present Chief Justice.
I'm sure this is a topic which cannot be, discussed and reached a conclusion in 25, 30 odd minutes. But we're unfortunately running short of time. Thank you so much, Advocate Parashar, Satya, and Mr. Chandra as well for sharing your views and insight. As our experts were pointing out, clearly there are various aspects to ensuring affordable justice to the people in the country. Cost is just one part of it. Of course, making people aware about their legal rights, about what kind of facility they can avail at a particular court or legal services is also equally important. But then there are deeper issues with judicial reforms, which have been debated, discussed threadbare for quite some time now, and hopefully will be resolved in the near future. We'll keep a close watch on all these aspects and come back again to you with details. Till then, keep watching Sansad Television. Thank you.